Pahang tensions have resurfaced over the controversial clearing of Musang King durian orchards in the Batu Talam Forest Reserve. In 2021 and again in April 2025, the Pahang Forestry Department carried out operations to cut down durian trees planted by local farmers citing illegal encroachment on protected forest land. Around 16.5 hectares of farmland were destroyed despite an ongoing legal dispute. The farmers claimed they had been informally promised land ownership decades ago and had submitted applications for land licenses. They argued that their presence on the land was long-standing and not without basis. The state government, however, insists that the land remains part of a gazetted forest reserve. For more insights, we go live with our reporter in Raut Pahang.
Ayah, kenapa kau mau tebang ini pokok, Ma? Sudah lama saya bekerja ini.
Assalamualaikum dan salam sejahtera. Saya Nurin dari Berita Terkini 999. Kami kini berada di lokasi di mana satu pertikaian panas sedang berlaku antara sekumpulan petani durian dan pentadbir daerah Raut. Difahamkan, pihak berkuasa sedang menjalankan operasi penebangan pokok durian milik petani-petani tersebut. Encik, boleh Encik bagi tahu kami sejak bila Encik dan petani lain telah duduk di tanah ini?
Saya dan orang lain semua dah duduk sini 20 tahun tanam ini durian. Tapi sekarang ni macam mana dengan atuk kami sudah tanam ini lama dah. Ini tidak ada tiba-tiba sebuah kena tebang. Ini tidak aci.
Itulah luahan petani yang berisiko untuk dihalau dari tanah mereka sendiri. Kembali ke studio.
Wait, did you know that this case actually falls under the law of torts? More specifically, it involves a cause of action known as trespass to land. Trespass to land happens when someone intentionally enters or interferes with land that belongs to someone else without permission.
In the 1970s, a group of local farmers began settling and planting Musang King durians on land within what is now known as the Batu Talam Forest Reserve in Raut Pahang. Many of them claimed they were placed there under an informal resettlement scheme and had worked the land for decades. Over the years, they submitted applications for land titles and licenses, hoping to make their farming activities legal. However, they never received official land ownership. The state government maintained that the farmers were illegally occupying forest reserve land without valid documents. Then, in 2021, a group of durian farmers filed a claim of trespass to land towards the government of Pahang, upon which the Pahang Forestry Department began enforcement operations to clear these farms. The government said that the orchards were on protected forest land and that the farmers were trespassing. As a result, about 15,000 durian trees were cut down. By April 2025, around 16.5 hectares of durian orchards have been cleared. During this time, the government also introduced a land leasing scheme through Royal Pahang Durian Resources, a joint venture between a private company and a state agency. Farmers were told that they could continue working the land if they agreed to sign contracts under the scheme. But many farmers felt this was unfair. They said that they had been farming there for decades with informal promises of land rights.
So, what is the legal issue here? The issue is whether the Pahang state government, through the forestry department, acted unlawfully by entering and destroying durian orchards cultivated by the farmers on the state forest reserve land.
The first element concerned in the claim of trespass to land is possession of the land. It is important to note that only a person who has exclusive possession of land may sue, as the law protects a person's possession of land. The issue of possession is a question of fact. A land can be in an actual possession of someone, or it can be in possession in the legal sense. However, the court must emphasize that a mere occupation without the requisite intention and control does not in itself amount to possession in law. In simple words, a mere action of occupying the land, regardless of the time, does not amount to possession of the land. Given the facts of the case, it appears to me that the farmers are not legally entitled to neither occupy nor possess the land. Hence, now the most appropriate issue to be raised first is whether the durian farmers are squatters to the land. If they are, then their claim will be unsuccessful, as squatters have no rights in the eyes of the law. This position is well supported by the case of Siddiq bin Haji Muhammad and the government of Perak, which was decided by the federal court in 1982. So in this case, some of the appellants had opened up a large jungle area to be developed which belongs to the state government. The appellant refused to stop working and vacate from the state land when notice was issued, as they asserted that their rights to remain on unoccupied land which they pioneered and opened, and they occupied. However, the original claim from the farmers was rejected by the court on the ground that the squatters have no right neither in law nor in equity, making any claim from squatters shall not succeed. Thus, I can conclude that the farmers had failed to satisfy the first element of trespass to land, as they are squatters and they failed to prove that they are in possession of the land.
From the article Eviction of Unlawful Occupiers of Property in Malaysia, written by the Sharifah Zubaida, Zuraida Ali, and Nur Asia Muhammad, one of the trends that is discernible in relation to cases of unlawful occupation of the land are brought to the court. In such cases where the occupiers seek for a declaration that they have a legal right to stay on the land by relying on long use as well as the representations made by the state officials in relation to their stay in the land. In such cases, actually the court have held that the law is clear that unlawful occupiers are not entitled to such declaration. From our case, Durian farmers have occupied the land for many years, possibly with tacit approval from local authorities or maybe politicians. Now in the case, the land, which belongs to the defendant, which is the state government of Pahang, invade their own land actually. It's not really invade. Using their own land legally, but the Durian farmers still attempt to argue that their long-standing use and past state tolerance give them right to remain, or now even suing the defendant for trespassing. So by applying the trend from the article, the Durian farmers are actually the one who is unlawful occupiers, which they cannot rely on the ground of their long occupation or prior tolerance by the state to claim a right to stay. The court have consistently held that long user and state representations do not create legal rights over the land. Therefore, any claim by the Durian farmers will actually fail, as they have no legal right or legal title or recognized interest in the land.
Now, I shall address the second element required to establish trespass to land, that is unjustifiable interference. In the case of Yip Shoshan and Sin Hapli Marubeni Sedan Berhad, the court dealt directly with this principle. The material facts are as follows. The plaintiff and the defendant owned adjacent lands. The defendant, while constructing a golf course and a large residential commercial development, allowed debris from the construction works to spill over and accumulate on the plaintiff's land. This formed a steep and dangerous slope. The court held that the defendant was liable for trespass as there was an unjustifiable interference by allowing materials to enter the plaintiff's land without consent. So, relating to our case, unjustifiable interference may take three forms. Firstly, by wrongful entry. Next, remaining on the land beyond permission. Or lastly, placing things on the land without consent. Here, in this case, we are dealing with the first category, which is wrongful entry. This includes entry by a person or animal into land or building possessed by another. However, in this situation, this element is not fulfilled here as the Durian farmers do not possess the land. The state, as the legal owner and registered proprietor, had the rightful authority to enter and manage the property. Their actions were justified and lawful. Therefore, based on all the evidences and legal principles, we decide that the Durian farmers cannot sue the state for trespass as they are not the legal owners. Instead, the farmers themselves are considered trespassers or, to be exact, squatters for unlawfully occupying the land.
We supported the decisions of the court regarding the Durian farmers case, in which they are the unlawful occupiers. and have no legal rights to sue the defendant. Why, you might ask? First, the decision is grounded in well-established legal principles governing land ownership in Malaysia. Although the Durian farmers cultivated the land for decades, they did not hold any legal title under the National Land Code 1965. The core doctrine here is nemo dat quod, non-habet. No one can give what they do not have. Without registered ownership, the farmers cannot claim possessory rights or sue for trespass against lawful authorities. This is not just technicality, but it is a fundamental to how land law operates in our country. This approach upholds the torrent system, which is central to Malaysian land law. The torrent system, applied from the Australian law, guarantees the indivisibility of title, meaning that once someone is registered as the owner, the title is secure and protected them from informal claims. Allowing long-term occupation for unrecorded promises to override registered ownership will undermine the legal certainty and disrupt the entire system of property governance. It will make land transactions unpredictable and open to the door of endless disputes. Furthermore, these decisions serve for the broader public interest. By denying legal recognition to the unlawful occupation, it deters encroachment and protects state-led development and conservation efforts, especially in sensitive areas like forest reserve. If we were to endorse such informal claims, it would set a dangerous precedent and encourage further encroachment on public land.
From the analysis, it is evident that for a claim to trespass to land to succeed, there are two elements to be fulfilled, both in English and in Malaysian law. The Malaysian court has addressed numbers of claims to trespass to land as it is actionable per se, which means that there is no need to prove the actual damages, as it involves direct interference to the use of one's land. For as long as all the elements are fulfilled, parties may succeed in torts of trespass. For instance, in a case decided in 2017 by High Court of Johor Bahru, the case of Johanda Realty Sendirian Berhad and another, and Ketua Pengarah Jabatan Pengairan dan Saliran Malaysia and others, the plaintiffs in this case, who are the landowners of five pieces of land in Pontian Johor, sued many parties including the state of government as they took part of the plaintiff's land to build a river embankment and to change the path of the river. The judge in Johandra's case, in giving his judgment, cited the wise saying uttered by Wan Yahya in the case of Tan Wee Chun and Ong Pek Seng, and another that was decided in 1986. He stated that trespass to land, unlike criminal trespass, is completed once a person wrongfully, albeit peaceably, intrudes into the land that is in the possession of another, even when no damage is done. Trespass to land covers all unlawful entry and includes taking possession, pulling down, or destroying anything permanently fixed to the land. The aforementioned statement reiterates that trespass to land is actionable per se and there are two elements to be satisfied. Thus, the court in the case of Johandra allowed the plaintiff's claim of trespass to land as both elements were satisfied. Therefore, we highlighted that in order for a claim to trespass to land to succeed, there are two elements to be fulfilled, and trespass is always actionable per se.
Next, referring to other levels of court decisions, we can look at the Court of Appeals ruling in Yip Shoshan and Sinhabli Marubeni Sedan Berhad. The Court of Appeal affirmed the High Court's earlier ruling on continuing trespass. This decision clarifies that a plaintiff can maintain a cause of action for trespass even if they were not in possession of the land at the time the initial trespass occurred. The key point is that the plaintiff must have come into possession while the trespass was still ongoing. This judgment strengthens the earlier doctrine established by the High Court in 2002, where the court relied on the relation back principle to confirm the plaintiff's standing. The Court of Appeal clarified that for continuing trespass, it is not necessary for the plaintiff to have legal possession at the moment the trespass first occurred, as long as the wrongful act continued when the plaintiff gained possession of the land. This clarification has significant implications, especially in cases where possession changes hands during ongoing unlawful entry or interference.
This decision will most likely set a very clear precedent for future cases in which it will reaffirm that long-term occupation, even with informal promises or historical arrangement, does not grant legal rights without a formal registration. This will strengthen the integrity of torrent system and ensures that only registered proprietors enjoy legal protection. Future claimants who rely solely on historical use or verbal assurance will face significant challenges unless they have proper documentation or a valid title. For example, for the Aboriginals, they have the rights to the land because of their Aboriginalities. Additionally, this ruling empowers state authorities to enforce land laws more decisively, especially in cases involving encroachment on government land or forest reserves. It may also encourage long-term occupiers to regularize their land to use formal legal channels rather than relying on past informal arrangement. Of course, decision may spark debates over fairness and the need for clearer or more transparent land allocation policies. But ultimately, it reinforces the rule of law and the importance of certainty in land ownership for the benefit of a society as a whole. Thank you.